Justice Ketanji Brown Jackson was at the White House last week at her historic investiture ceremony. And this week, she heard her first case as a Supreme Court justice. And unlike some other freshman justices, Justice Brown Jackson had a lot to say about the Voting Rights Act, the 14th Amendment, and the issue of race. How will Justice Jackson's presence on the court impact the court and decisions on landmark cases involving voting rights, affirmative actions, guns, and even state elections? And will her presence help improve the credibility and ratings of this United States Supreme Court? Experts weigh in, all coming up next.
Live from Los Angeles, this is the Special Report with Areva Martin.
This week, the justices in the nation's highest court heard 2 hours of arguments in the latest showdown seeking to force Alabama to create a second Black majority congressional district. About 27% of residents in that state are Black, but they form a majority in just one of the state's 7 congressional districts. The conservative court, in a 5-4 ruling earlier this year, blocked a court's efforts to carve out a second Black majority district in time for these November midterms. But in the oral arguments that were heard yesterday before the court, Justice Jackson eloquently dismantled the claim that the 14th Amendment was supposed to be racially neutral. She reminded the litigants and her fellow justices that the framers themselves adopted the Equal Protection Clause of the 14th Amendment in a race-conscious way. The framers, she said, were trying to ensure that people who were discriminated against, i.e. the freed former slaves, were actually brought equal to everyone else. She insisted that the primary purpose of the post-Civil War edict was to empower formerly enslaved people and to overturn a system of violent white oppression. Now, there's nothing race neutral about that, and Justice Jackson said that with extreme confidence. Now, despite her incredible history lesson, which has landed her lots of praise and applause from legal experts around the country, it seems like the 5-4 conservative court, or the 6-3 conservative court, I should say, was leaning towards siding with the state of Alabama and continuing to undermine the Voting Rights Act of 1965. Now, Justice Jackson may not be able to save the Voting Rights Act, and she's already said that she's going to recuse herself from the big case that's coming up on October 31st about affirmative action. But the question is, what impact is Justice Jackson going to have on this court? And here to help us break it all down for our leadoff discussion is Professor Marjolaine Armstrong. She is a professor at law at the University of California, Santa Clara Law School, and she's a friend of the show. Good morning and welcome back, Professor Armstrong.
Good morning. Thank you.
I think you can tell from my excitement that I am super hyped about Justice Jackson, going through this process of being formally sworn in to sit on the United States Supreme Court, and then hearing her first case. And unlike Justice Thomas, who was quiet and who still remains pretty quiet on the court, this freshman just was, she shot out like a cannon and asked a lot of questions and then gave this pretty impressive history lesson on the 14th Amendment. How would you rate Justice Jackson's first day on the job?
Well, it's very exciting, and it's very impressive in terms of how she was schooling these people who have had such a limited view of what the 14th Amendment means and the purposes for which the 14th Amendment was enacted. And I do want to say that the court split the lawsuits between from Harvard and the University of North Carolina. So Justice Brown Jackson can hear the University of North Carolina case. She can't hear the Harvard case because she was on the board of overseers of Harvard, but she doesn't have that limitation with respect to UNC.
Great. Yeah, glad she'll be sitting on that important affirmative action case. But this voting right case, very disturbing. Similar challenge in Louisiana that's going on, that's on hold. And because of that lower court's decision, this single majority district in Alabama, that's the way the voters will find themselves voting in these November elections. Do you see the Voting Rights Act surviving at all, given the attacks that have been made on it since the Shelby decision and now this Alabama challenge?
Well, the Voting Rights Act should survive. And one of the questions is, how long will this court be this particular court? If there was a sufficient majority in Congress to revise the act again and to update it, that might address the questions that the court was raising in the Shelby case, because one of the reasons that Shelby found that the Voting Rights Act review provisions were unconstitutional was because they really hadn't been updated. They'd just been renewed without really examining them several times since they were first enacted in the 1960s.
So again, when we talk about Shelby, we're talking about that Section 5 pre-clearance provision, which said that before a state could make any major changes to its congressional maps, it had to get approval of the Department of Justice if it was going to have any racial impact. And the court pretty much struck down that pre-clearance provision in the Shelby decision.
As it applied to the states it did apply to, because it only applied to, I think, 9 states and some counties. And so by eliminating that coverage, those states no longer had to submit their voting changes. But if the coverage was amended to, I'm not sure exactly what it would do to please Justice Roberts, but I think the Senate could certainly, or Congress could certainly amend that process by which states have to submit their new laws. And frankly, they should be able to do it based on a number of the actions that the states have taken since Shelby, because they've been very clearly directed at reducing minority participation in voting.
If the court does side in this Alabama case with the state of Alabama, what will that mean for other states that are engaging in this gerrymandering and efforts to limit the influence of Black voters?
Well, it's giving them the ability to continue doing that without concern about having to submit those changes to the Justice Department. But there is also the availability of lawsuits to challenge these types of changes. Unfortunately, the federal court has been kind of stacked really recently with judges who are probably going to be hostile to the claims that people are making with respect to violations of the Voting Act. And unfortunately, what we're seeing in terms of these restrictions really has pretty deep roots in terms of the attempts by essentially people associated with the Federalist Society to have judges appointed who are hostile to progressive views and who are hostile to the Voting Rights Act. And this has been going on really since the 80s, trying to build up to this place. And with the appointment of Gorsuch and Kavanaugh and Coney Barrett, the Federalists and people along that ilk have just had their dreams come true. A 6-3 majority. I don't think they ever hoped for as much, but that's what they had, in part because of the manipulations of Mitch McConnell and applying different standards when when I guess Scalia died during Obama's administration to when Ginsburg died during Trump's administration. So Trump got to appoint 3 justices, 2 of which were questionable in terms of the procedure and going ahead, and one of whom was pretty questionable in terms of his judicial temperament when he was being vetted by Congress.
So talking about this hand selection of these Federalist judges and their activism and their opposition to progressive policies and positions, let's talk about Eileen Cannon. This is the judge appointed by Trump, young judge, in the hot seat because in this case involving the search of Trump's private residence, Mar-a-Lago, where it's undisputed that he had confidential documents that were not to be removed by anyone in his personal possession, after his lawyers had signed an affidavit indicating that all of these confidential White House, U.S. government documents had been returned. This young judge appointed by Trump bends over backwards, makes arguments for Trump's pretty pathetic legal team, and appoints a special master, then overrules the special master, seemingly extending every courtesy, every benefit of the doubt, and really favoritism towards Donald Trump. And now he's getting a shot at challenging the 11th Circuit Court of Appeal, going back, or not going back, but going up to the United States Supreme Court. So can Trump ever be held accountable if he's going to be appearing before handpicked judges like Cannon and then have the cases challenged and make their way to this 6-3 very, very conservative Supreme Court?
Well, that's a really good question because of the number of appointments. I mean, certainly there's been pushback from the Court of Appeals, but in terms of the number of judges who were appointed by Trump and the composition of the Supreme Court, you're asking a really important question. And I think there's might be some concern on the part of the Supreme Court of not upholding the rule of law, because the Supreme Court is in the view of everyone. Not that many people are closely following what lower district federal court judge is doing, but to have the Supreme Court essentially say that the law doesn't apply to a former president, I think would damage the court even more than it's been damaged. And I would imagine that Justice Roberts, at least, would be hesitant to not try to recognize the rule of law. Of course, he's only one other justice. I'm not sure that the issues involving Trump are quite as ideological as the issues so far, such as affirmative action and abortion. So there might be more of an understanding of how damaging it is to not have the law apply to Donald Trump. The other thing is that this is a huge security problem. I mean, what Trump has done has really, as far as possibly endangered the United States. It certainly made it more dangerous for people who were working for the United States, whose identities were kept secure, and the carelessness with which Trump has used these files. And we don't know where this information has been shared or not. I think it's really such a kind of threat to the United States that I hope it won't be something that's purely decided on ideological or political grounds.
Yeah, we had hoped that would happen at the district court level, and this judge seemingly in the beginning, even questioned whether she had jurisdiction over this case, given that it was pending before another judge, and it was clear that Trump and team were forum shopping to even file a case in front of her. But then she took this this, hard turn, and now has been basically the mouthpiece for Trump. But you mentioned something important, Professor, and that's Justice Roberts and, his role as the Chief Justice. We know he's been out on the speaking circuit. He's given several speeches where he's tried to combat this notion that the court has a legitimacy problem. He's tried to defend the court by saying, its job is to interpret the law. And simply because people may not agree with it doesn't mean that we should question the legitimacy. And he was really responding to the critique of this court and its overturning of this precedent, Roe v. Wade. And I think he even knows that there is no defense to that decision, given, the rolling back of rights, and the court had not done that in its history. But Justice Kagan, it seems like these guys are in a pretty big battle. She made 3 appearances herself and basically said legitimacy had to be earned, and that the way this court was acting, it wasn't earning legitimacy, and basically said it shouldn't be running around inserting itself in every hot button issue in America. So what do you make of this clear tension, not just ideological tension between the 6 and the 3, but it seems like this may get personal because Roberts is trying to defend the legitimacy of the court, and Kagan is saying, wait a minute, you're not entitled to legitimacy from this country because you're not acting in a way that has earned you that legitimacy.
Well, Roberts took a different position than the other judges in the majority in the Dobbs case. He wrote a concurrence, and in his concurrence, he said he didn't think it was appropriate to overrule Roe versus Wade, but he did think that the law that was being challenged in Mississippi was actually within the undue burden standard, which the court was applying until the Dobbs case. I keep calling it Hobbs because it's kind of Hobbesian, but the Dobbs case is a case in which you have 5 justices voting to uphold the law, but Roberts really tried to say we shouldn't overturn Roe versus Wade, in part because of the legitimacy issues that it posed with respect to the court. And I also think that Roberts was probably aware of the political ramifications that might occur with overturning Roe versus Wade, because there's been a very visceral reaction. And this Dobbs case is a case that people are really affected by. So many Supreme Court decisions seem to not have anything to do with day-to-day life. But Dobbs was something that people really felt and feel, and they understand that the Supreme Court can influence the day-to-day and the important life decisions that people have to make.
That's a really excellent point. You are so right. Unless you are a lawyer or you are a political news junkie, you're not tracking for the decisions coming from the Supreme Court. But that was not the case with Dobbs. Everyday people are vested in that decision, understand what happened, understand the significance of it. And I think this case coming up on October 31st, the affirmative action case, is going to be like Dobbs. It is going to have, it's going to resonate with people in the same way because it's going to impact the lives of people, i.e. students. I want to bring on some additional guests because we're going to talk now about this affirmative action case, or the 2 cases now that you've told us they've been split by the court. First, Sally Chin. She's a graduate of Harvard University and was one of the 8 students that testified in support of affirmative action in the 2018 federal lawsuit, Students for Fair Admissions, Inc. versus Harvard. She's now an education advocate at Chinese for Affirmative Action. Also joining us is John Yang. He's the president and director of Asian Americans Advancing Justice, and Roberto Cruz is with us. He's the managing attorney for Latino Justice. So when I look at this panel, we are like the melting pot of this country, and all of us, because of our different races and ethnicities have, I think, some personal as well as professional interest in what's going to happen in these affirmative action cases. This issue is about precedent, and that whole notion of what is precedent and when can precedent be overturned is going to rear its ugly head again in this challenge to Harvard University admissions policy, North Carolina admissions policy. And we know for the last 4 decades, the court has ruled that race may be one of many factors considered in college admissions. But now the question is, I think, Professor Armstrong, is whether the previous decisions making it the law of the land that race could be used as a factor were those decisions grievously wrong? The rationale that was used by Alito in overturning Roe v. Wade. What do you think about that, Professor Armstrong? And let me just add this: we know that these groups that are trying to, eliminate the use of race in admissions policies are using this 1954 Brown versus Board of Education case, basically that outlawed segregation in public schools and saying that affirmative action is a form of discrimination. So they're using this case that integrated our school districts to say, well, wait a minute, what these colleges are doing is a form of discrimination that was outlawed in the 50s?
Well, first of all, what was in existence with Brown versus Board of Education was a kind of subverting of the traditional rules of where students go to school. Because traditionally, students go to school at the nearest school to where they live. But segregation made the students have to go to schools based on their race. Obviously, nothing like that is happening with respect to the admissions to Harvard and to other schools that consider race as a factor. Harvard has always tried to have as diverse a population in terms of geographical origin as it possibly could, because Harvard sees itself as being an important place for training the leaders of tomorrow, and everywhere in the country will need leaders. So they can consider geography, and geography it isn't something that's considered to be particularly problematic, but considering race is considered problematic based on calling this events in Brown versus Board of Education as being the same kind of events that go on when you're trying to have an inclusive class. So rather than excluding people or placing people into certain schools because of their race, Harvard and other schools are trying to have classes that reflect all of the United States. And the Supreme Court has long done this false equivalency in terms of including people, excluding them. I mean, if you look at the population of students at Harvard, it's not as if they have a policy of excluding white students or Asian students. It's a very diverse school, and certainly it's majority white. And so to say that is, or what Harvard is doing is the same as excluding people from its campus and its student body because of their race is really flipping what they're doing.
Yeah, I want to bring you into the conversation, Sally. You were a student at Harvard. I'm a graduate of Harvard too. So this is very personal for me, and I would be really negatively impacted, or would be very upset if race couldn't be used as one factor. It's not used as the sole factor. But what got you interested in this case? I know you testified in the lower court case. How did you get involved in this?
Right. So as a student, I was really involved with a lot of different types of campus activism, including sort of a lot of multiracial coalition work, fighting for the inclusion of ethnic studies, the support of Latinx studies, Native American studies, Asian American studies teachers. And when this case sort of started to be heard at the federal level, a lot of students were really concerned. And Personally, I testified to how I grew up as the daughter of working class Chinese immigrants who speak limited English. And as part of my sort of background, I grew up as a translator and an advocate for my family from a really young age. And that ultimately shaped a lot of my perspective and my motivation and aspirations for what I wanted to do later in life. So it certainly affected my own admissions process. But affirmative action was also really crucial to my actual campus experience, right, in terms of diversity and education. When I say that, I worked with a lot of other students of color on campus to advocate together, that was a really critical learning experience, not just at Harvard, but I would hope for that to be the experience in terms of education everywhere, to learn from people who have perspectives that are different from our own, and to work together, because none of our work is in a silo. And my work today at Chinese for Affirmative Action takes on issues like multilingual education, immigrant rights, and so much more that is about learning from one another, working together, and uplifting these issues that affect us all.
And so, John, Sally talked about how important that diversity on the Harvard campus was for her as a student. Stats tell us that in 1976, more than 80% of college students were white. So had Sally been on that campus in the 1970s, she would have had a very different experience. You come full circle to 2016, only 57% of college students are white. And you gave us a stat for 2021, 22% of Harvard students, this is Harvard now, are Asian, 11% Black, 10% Latino, 2% Native American, and about 52% are white. So Harvard is a very diverse campus. So what's the issue? Why are we in a lawsuit if we have a campus that is as diverse as this lawsuit is? And we heard Professor Armstrong said Harvard and other schools are being inclusive. They're not excluding white people. White people are still 52% of the population. So who's complaining in this lawsuit?
Well, thank you for asking that question. And this is an important one. If we were to really look at the background for this lawsuit, it was instituted by a person named Ed Blum. And when he instituted it, he wanted to protect white students, frankly. But in doing so, he stated very expressly that he needed an Asian plaintiff because he recognized that by having an Asian American plaintiff, that would cause our communities to divide against each other potentially and to draw a different sort of attention. Now, I want to be clear. Asian Americans support affirmative action. All of the polling that we have done for many years show that Asian Americans generally support affirmative action, around 70% in favor. And so that is one thing to make clear about all of this. The second thing is, let's be clear about what's happening at Harvard. Race, as you said, is one specific factor among many, many factors in admissions. There is no quota that's happening at Harvard. Let's be honest about this. If we saw actual discrimination at Harvard, my organization would sue Harvard. But that's not what happened. The district court engaged. Oh, sure.
Let me stop you because I want to make sure everybody's clear on this.
Yep.
So Ed Blum gets an Asian plaintiff to be the face of his lawsuit. What is that Asian plaintiff's gripe? What is that plaintiff's complaint?
Well, their gripe is essentially that, but for affirmative action, Asian Americans would have a larger presence at Harvard or larger presence, and that affirmative action is somehow holding Asian Americans back.
So affirmative action is allowing that 11% Black, that 10% Latino, and those could be Asian students, but for affirmative action, because they're saying Asian students have higher test scores and have better applications than other minorities that applied to Harvard. Is that essentially the argument?
Yeah, it's very twisted, but in some ways that is. But the problem is, even when you get into that argument and you break it down, it doesn't break down so easily. And what Blum is really trying to feed upon is the so-called model minority stereotype for Asian Americans and get that easy narrative, if you will, to get people to buy into it. But if you start looking at test scores, you start looking at all of the factors and the diversity of the Asian American community, we actually benefit from affirmative action more than we are hurt by it.
And Roberta, where does the Latin community stand on affirmative action? We heard John say that the Asian community overwhelmingly supports affirmative action. Where is the Latino community, if you know?
Well, in terms of the Latino community, we see this as an attempt to make the university admission process colorblind. And as you know, colorblind is not what really America stands for. This is not, our goal really is not to achieve equality like they do in France, where everybody's equal. Here in the United States, the Latino community feels that we're not looking for equality because we're not equal. What we're looking is for equal protection, which is what the 14th Amendment of the Constitution provides for, protection. Just to make sure that we are not colorblind, we're not all equal, that we have to be race conscious, because race is an important part of a student's overall person, and that's where we stand with in this matter with our community.
Professor Armstrong, what's going to be the argument? Can you foreshadow for us the argument at Harvard and then North Carolina when their case comes up? How are they going to defend their admissions policies? I don't know that what Roberto said about this not being a colorblind society and folks not being equal would fly with Alito and the conservatives on the court that, have bought into, or like to at least, suggest that they bought into this notion that we are colorblind, and they deny systemic racism, they deny, white supremacy. So I don't suspect those are going to be the arguments by Harvard and North Carolina. What do you say those, what do you think those universities are going to argue?
Well, they're going to argue that having a diverse class or diverse composition in their classes is important educationally for all of the students. Again, with the idea that the people who graduate from these elite schools are going to be leaders. They're going to be leaders of a multicultural, multiracial country. And if students don't know how to work with people of different races, or if students aren't exposed to different backgrounds, they're just not being well educated.
You and I get that, Professor Armstrong, but I just don't see that landing with those 6 and maybe 5 or 6 conservative judges. What do you think the most significant argument is that can be made that might land with? I don't think they care about diversity or a diverse workplace. I think they're so myopic in their view of the world. I can't see them caring about that.
Well, I think there's different perspectives. One interesting perspective is that of Clarence Thomas, who was a dissenter in the Michigan case that upheld affirmative action in law schools. And interestingly enough, he had almost segregationist view in terms of the idea that Black schools or traditionally Black universities are really best for students, for Black students, and that the whole issue with respect to the cases that are going to the Supreme Court is about these elite schools. So Thomas has this kind of strange vision. I think with respect to the other justices, first of all, it's interesting to see what Kavanaugh does and what he says, because he's actually been very good with respect to having law clerks who are racially diverse. And I don't know if he's going to say anything different from the rest of the justices. But I think that for everyone else, Harvard's not going to be persuasive. I think affirmative action, as sanctioned by the Supreme Court, is gone.
Wow. Oh, John. Oh, that's that's pretty ominous, Professor Armstrong. But hey, you're probably right, and I think we're not all ready to accept that in a way we weren't ready to accept the overturning of Roe v. Wade. It was such a devastating blow, but 40 years of upholding affirmative action or the use of race as a single factor may be gone, John. Can you think of an argument that might resonate with this majority conservative court?
Whether the argument resonates, I'm not sure, but I think that Justice Jackson's questioning from yesterday in the voting rights case is predictive of an argument that should be used, which is the 14th Amendment has never been about colorblindness. Our laws prohibiting discrimination have never been about colorblindness. It's about how do we prevent discrimination? How do we procure, have educational opportunities, a system where we have better educational equity, right? And if we're talking in that manner, then race has to be a factor, given the structural racism, given the structures that exist right now.
But do you agree, John, that this court maybe is in denial about structural racism? Because wasn't that the argument, and you can weigh in, Professor Armstrong, if I'm wrong, about, we've seen that in the voting rights cases. Wasn't there a statement made by one of the justices that race was no longer being used as a factor in these gerrymandering, or these drawing up of these congressional districts? I'm not sure this court accepts that there is a system of racism that still is pervasive in all of our institutions.
Well, ironically, Justice Roberts said that the Voting Rights Act was successful and wasn't needed anymore. And then the moment you took out pre-clearance, states went back to the kinds of things that they had done previous to pre-clearance and the Voting Rights Act. And I just wanted to say something about colorblindness. The term comes from a dissent in Plessy versus Ferguson, the case that essentially upheld separate but equal. And the dissent was saying that the law should be colorblind. And had the law actually been colorblind at the time that Plessy versus Ferguson was decided, if that had been the policy, we would be in a very different position. Since Plessy versus Ferguson until the 60s and 70s, Blacks were essentially denied, and other minorities denied political participation, protection, equal protection they were denied. And so Plessy versus Ferguson set us back years because the court didn't follow the idea of colorblindness. And so evoking it now, after such a long time of not recognizing that the law should not consider people's color or people's race in distributing benefits and protection, at this point, it's not really fair to apply colorblindness since it wasn't applied for so long.
I think that's hypocrisy, and I think that's pretty accepted amongst conservatives and Republicans. It's what we see on display every day. Sally, let me ask you this. So John says that this Ed Bloom gets a Asian American plaintiff to be the face of this lawsuit. As an Asian woman yourself, did you suffer any backlash because you stood up for the use of affirmative action? Have you experienced, any negative response from that portion of the Asian community that is, I guess, standing with these plaintiffs?
Yeah, I think, highlight first that, we've heard so much about Students for Fair Admissions representing their student plaintiffs, but I would also just name that there wasn't a single student witness that came forward. A lot of what they sort of brought to court was just statistical manipulation of hypothetical students that would or would not have gotten in. And I would say that, for the 8 students and alumni that participated, right, we wanted to share our stories because our experience is very much, it was about human dignity. It was about seeing us as whole people, including our race and ethnicity and our experiences of racism in this country. And certainly it's high stakes, right? We were, a lot of us, coming forward to talk about really personal details. So, for that one piece aside, to name, this small but vocal segment of Asian American communities that are not in support of affirmative action, as John named, right? We know the statistics around Asian American support for these kinds of policies. I think a lot of it is really engaging them around what actually happens, because anti-Asian racism is very real. And I think a lot of people who face sort of the opacity of the admissions process, who have questions about it, who are disenfranchised from so early on, right? Whether it's about not being able to engage in a PTSA or like a school board just because they don't offer services in your language. I think that's a really key question about sort of institutions and how they are serving students of color to get to this point where people are so disillusioned or distrustful of what is happening in our society, and how to open up those opportunities. So it's more than just Harvard, right? I think that's a really key part of what I hope to get across, because roughly half of Asian Americans enrolled in post-secondary education are actually attending community college, right? So what are we doing to actually serve where students of color are? And there's a lot at stake for this case. We want to see things like targeted scholarships, culturally competent counseling, things that are race conscious and that are helpful for Asian Americans and for all students of color. And we want to see sort of that provided. And I hope that for people who are, in opposition and who have, sent, their opinions directly to me, that we can sort of talk about what is actually needed and build some of those bridges, right? Because I think we all want quality education. We want opportunities for all students. And, I think a lot of that comes from race-conscious policy and programming. And in some ways, outside of admissions, I think a lot of people would agree too.
Yeah, I hear you, Sally, and I appreciate your optimism as a young recent college graduate. I don't, unfortunately, there's a huge portion of this world that does not want diversity. And as John said, the folks that are driving this lawsuit, they're not interested in diversity. They're not interested in making college available to all students, of every ethnicity, every race, every socioeconomic class. They're interested in white students. We just got to call it what it is. They're concerned when they see these numbers. This is huge. From 1976, where 80% of college students were white, to today, where that number at a place like Harvard, and Harvard is very important to white people. Let's be very clear. The Ivies are very, very important. It's like God. To have that number go from 80% down to around 51, 52% is huge. So they're not just looking at that as where we are today. They're thinking, oh my God, in 10 years, that number could be under 50%. This is the browning of the nation, right? This is what happens when this country becomes more diverse. It impacts every institution. So colleges won't be 80% white. Colleges might be 30% white. John, is that what you see this about? Is white folks like Ed Bloom thinking long term, this is what's coming? White folks not being in power at institutions like Harvard.
Well, this is what goes back to what we believe about America. America as a country is becoming more multiracial. If you think about the 2020 census, the percentage of white Americans is dwindling. So that's what we're also seeing in colleges. That's what we're seeing in any walk of life. But then the question becomes, how do we as a society live, right? Are we really going to be in our tribe of ethnicities, or does America stand for something more than that? I, for one, believe that America stands for something more than that. And those that just focus on their white tribe, so to speak, are the ones that are living in that anachronistic world.
So, Roberto, is your organization or any like MALDAF, are they filing or have they filed amicus briefs in these cases?
Yes. Latino Justice joined our partners at Brown Rudnick by filing an amicus brief representing 19 mostly Latino organizations like the Hispanic Federation, the League of United Latin American Citizens, the Hispanic National Bar Associations, to name a few, because we believe that preserving race-conscious admissions policies in higher education is critical to the advancement of Latinos. I mean, we are the nation's fastest growing minority, and thus our future is also America's future. So we just want to make sure that we are an educated population that can also enter the workforce and, like your previous guest stated, that we can become part of the leaders of this community. So yes, it's we're making sure that we get our voice heard in this case.
Professor Armstrong, you told us that the cases have been split. So on October 31st, which case will be heard first?
Actually, I don't know.
Okay. But we know there are two cases, and Justice Jackson will sit and hear the North Carolina case. She's recused herself from the Harvard case. When this decision is made, and Sally raised the point that this isn't just about Harvard, right now, do we know what percentages of schools use race as a factor? Is that universal throughout most colleges and universities, or is it limited to a certain group?
I would say most colleges and universities, a very high percentage of them do. So you only have a few schools that wouldn't consider it at all because, again, most schools think that it's very important for the education of their students to have a multiracial, multicultural student body. So there's the exchange of experience and ideas and helping people to lead in the future. One of the biggest proponents of the decision in Brown versus Board of Education was the military, because the military was looking to the time at which they would have a number of people of color, and they wanted to have leaders, people who were educated, who could be officers. And so they thought it was very important not to have segregated schools and not to give students all students the ability to have good educations where they got to know people of other races.
Well, we know the Supreme Court has a couple of has a whole docket of really important cases, and the issue of race is going to come up again. It's going to come up in a case challenging the Indian Child Welfare Act, that act which basically says that Indian being, i.e. Native, children must be given in adoption proceedings. Preference must be given to placing those Native children in Native homes, Native communities. And there's a challenge to that Child Welfare Act, the Indian Child Welfare Act, by white women, saying that that is a form of discrimination and that Native children should be able to be adopted into white families and to other families. What do you make of that case, Professor Armstrong? Where does the court go with that?
Well, again, I don't know for sure, but if they don't understand the history, then the history is that Native children were taken from their Native families all of the time, involuntarily sent to schools, essentially adopted so that they could be trained to be servants and to support white families in terms of having people that they could reliably use as again, servants. So I don't know if any of the justices will think that history is important. But we did see Justice Gorsuch find that the territory that was covered by a treaty from the 19th century was essentially much broader than the reservation in Oklahoma. And he recognized the history and he recognized the treaty, the validity of the treaty. So he's from Colorado. He might have a different perspective. I don't know.
Yeah. We also have that election case, Republicans challenging, the laws that dictate how elections are decided in this country and wanting to give the states the right to decide what electors to send, basically giving state elected officials the ability to overturn the will of the people in elections. A lot's going on in this Supreme Court, this docket this year with Justice Jackson. We'll be watching her. I want to thank all of you for your efforts, your tenacity, your advocacy on this important issue of affirmative action. Sally, courageous, coming forth, giving testimony, telling your personal story and your family's personal story. Those stories we know are so moving. They make such a big difference. And thank you, Roberto, and the 19 other Latino organizations that have filed those amicus briefs. And I know, John, you're going to stay on this case. And we're going to watch this. And Professor Armstrong, of course, we'll have you back as we start to, get some sense about where this 6-3-5-4 court is on this incredibly important issue of affirmative action, because I think it's going to be as explosive as the Dobbs decision is because of Black and Brown and Asian students and the whole college admissions process being so important to families.
There has been one positive in terms of schools anticipating the possibility of the end of affirmative action, which is that schools are beginning to no longer rely on standardized testing in terms of being the major factor in admissions of students. And of course, given the eugenics history of standardized testing and the fact that standardized testing reflects your economic background more than anything, the elimination of standardized testing should expand if affirmative action is jettisoned. And I think that's good for everybody, really.
That's an excellent point, because some of the arguments, John, right, is that Asian students would be a larger percentage of these classes because they're scoring the highest on some of these standardized tests. But if you take the standardized test out of the equation, do we know what that would mean for the population of Asian students? Would that change the percentages according to this lawsuit? Those students would be eligible for admissions?
So it's interesting. There was a study done by Georgetown that said if you just focus only on standardized tests, what would happen? And at least for Asian Americans, I don't remember for the other categories, for Asian Americans, it would make not much of a difference, maybe a 1% to 2% gain in admissions. That's it. So again, this goes to what Professor Armstrong was talking about. It's like, let's think about other systems to consider the person's entire package, their history, all of the different factors that make a student who she is or who he is, and how we get to a university setting that is diverse, that is rich in all its contours.
And I'd like to think that, really smart places like Harvard, they're going to figure this out. If affirmative action is struck down in college admissions, they'll be able to use kind of this whole person analysis. They'll know who's Black, they'll know who's Latino, they'll know who's Asian, and they'll know, who's female, who's male, who's trans, who's LGBTQ, because it's all in that application. When you talk about the activities that you participated in, when you give your street address, everybody knows, your zip code tells everybody pretty much where you live in this country, unfortunately. So there'll be other ways that these schools can hopefully diversify their classes.
That's true, but I do want to say that we shouldn't have to hide it, right? The notion that on our college application, we can't talk about who we are and include our ethnicity, include our sexuality. You're right that the universities can figure it out. But why should they have to, right? We should be able to tell our own stories.
What's going to happen, John? I think if affirmative action is struck down, you're going to have college admissions folks telling students, say it loud, write it in big letters across your application. What distinguishes you? What makes you a unique student? What makes you a diverse student? I think that's what's going to happen, is that college admissions folks will start to ask students, tell us, about tell us about you and what makes you a unique candidate. And, there's code language, and we'll know that means just say you're Black, say you're Asian, say you're Latino. So, I just have to believe, and I kind of agree with Professor Armstrong, we probably will see the court do what the court is doing, which is denying a right that has been established in this country by precedent for over 40 years. But I think we'll figure it out, just like we are figuring out the Dobbs decision. We are figuring out how to make reproductive health available to women despite what this court is doing, because that's what we do as Americans. We just figure it out. Thank you.
And if I can just weigh in on one point, that student power is really, really important, and student voice. And I hope that the students who are ultimately at the crux of this case, take this as an opportunity to organize and make demands, right? I think to leverage the power that you have in your schools and to make demands of your institutions, even if they are not being, accountable, especially at the Supreme level, right? Think local, think about what you can do, and don't give up hope.
I love that. Think local. That's important because we have midterms coming up. Everybody should be thinking about local elections in addition to voting in those federal elections. Again, thanks so much to all of you for joining me this morning. We're going to stay on this important case. We're going to watch it to its conclusion. So watch this space. Oh, wow. What an important issue. I'm so glad we had a chance to talk about this before the case is actually argued before the Supreme Court, because now we'll get a chance to watch Justice Jackson at work. And I think already from her first week on the job, she's going to be such a dynamic member of this court. She's going to add so much to this court, not only her brilliance as a Harvard undergraduate and a Harvard lawyer and a former public defender and a former litigator. She's just going to add her lived experiences as a Black woman that is mothering two Black children that themselves will be applying for colleges pretty soon. So I just can't wait to see how Justice Jackson transforms this court. Even if she can't change the numeric makeup of this court, she's going to change the heart and the soul of this court. That I am certain of. Words to live by before I get it out. If there is no struggle, there is no progress. And we're struggling right now. But guess what? We're also making a tremendous amount of progress. Be safe out there. Remember, we're all in this together.